How many times have I told you to stop volunteering information during the course of your deposition? Would you like to know the answer? Come join me for a walk along this deserted island as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You are now at the point where you are going to be giving a deposition, which is pretrial question and answer testimony in your particular matter. Now, during the course of your deposition, which lawyers also call an examination before trial, you are going to be asked hundreds and hundreds of questions during the day. Questions about what happened to you. Questions about how your injuries have affected you on a daily basis. Questions about conversations you had with various doctors and other people. During the course of questioning, you continue to volunteer information, even though you were not asked to volunteer that information. And now, instead of your deposition lasting only a few hours, your deposition is lasting the entire day. And guess what? Because the attorney has not been able to finish asking all those necessary questions, now he has to bring you back for another day because he still has lots more questions to ask you. And I'm going to ask you a question. Why do you continue to volunteer information that you are not asked about? The answer is because you think that by providing the defense attorney with more information than what he's asking for, that will give him more information, that will help him recognize that you have a good case, that will help him recognize that your injuries are significant and permanent. Well, I'm going to share something with you right now that is going to disavow every one of those perceptions. By volunteering information that you are not asked about, you are doing just the opposite of exactly what you need to do. Now, what do I mean? The attorney is going to ask you a question about a conversation that you had with a particular doctor. And now you decide that it's critically important for you to go ahead and tell him about conversations you had with other people other than what he asked you about. Now, instead of your answer lasting all of 10 seconds, your answer goes on for 2 or 3 minutes. Why? Because you have it in your head that it's important for this attorney to know this information for some reason. Your attorney is going to tell you, no, that's not the case. Stop volunteering this information unless you are asked about this specific topic, unless you are asked about this specific conversation you had with another doctor, or unless you are asked, did you have any other conversations with anybody else at the hospital? Then you go ahead and answer the question. But if you are asked a very specific, very direct question, answer only that particular question. Now, there will be times when the attorney will ask you about what problems you have, what concerns you have today, or what the doctors have told you you're going to be limited from doing as a result of your injuries. And now you proceed to tell the attorney about those limitations, about those restrictions, about those things that your doctors have told you you will be unable to do or do with difficulty or with pain. In that instance, it is perfectly acceptable for you to go ahead and explain to the attorney about those limitations and those restrictions and those things you are unable to do today because of those particular injuries. But when you are asked a specific, direct question, don't go off on a tangent. Don't think for a second that that is going to help you in any regard whatsoever. The reality is that it won't. I promise you that the opposing lawyer is going to ask you many, many follow-up questions. And they're going to ask you questions about your conversations and questions about what you did and why. Don't think for a second that because the attorney has not asked an open-ended question that gives you free rein to go ahead and talk endlessly about every single thing that happened, that he's not going to follow up with specific individual questions. He will. I promise you he will. You know, in a criminal case where they arrest you and they have to give you Miranda warnings, they say anything you say can and will be used against you in a court of law. Since this is a civil matter involving claims of medical malpractice, that phrase and certainly Miranda warnings don't apply. However, what does apply is anything you say during the course of your deposition can and literally will be used against you by the defense at the time of trial. But keep in mind that the more you chat and the more you talk about things that were not asked about, you are giving the defense more ammunition to use against you at the time of trial. More ammunition to go ahead and contradict other information that was contained in the hospital record, other information that you and other witnesses have talked about or will likely talk about in the future. So pay attention to the question that you are asked and answer only the question that you are asked. Don't think for a second that volunteering is going to help change this attorney's perception of you and your particular case. You know, I realize you're watching this because you wanted to see the gorgeous scenery on this deserted island here. No, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.